What's up, everybody? Welcome back into The Lawyer You Know, and we're talking day 17 of Karen Reed's second trial, where we had some foundational evidence finally tell the jury something, why we're here, how some of the pieces fit together, whose DNA was found on what items. Not too much of it is very surprising, but at the end of the day, we get the answer from the judge on how she's going to deal with this expert scenario, how it's changed, what are the remedies going to be, what is she going to allow, what is she not going to allow, and what we think of that decision. Of course, I'm going to answer a lot of your questions, and I'm going to try to tell you what I would do if I found myself in the situation the defense attorneys are in now, and how I would try to use this to my advantage as much as is absolutely possible. So hit the like button right now. Let's get to it. All right. So, by the way, the first part of the video, I'll probably have morning voice for a while, especially because last night was Maverick's last flag football game. They won. He played awesome. It was so much fun, but it always takes a little toll on the voice. I'm out there coaching, screaming at 9-year-old kids, telling them where to go, where to stand, what to do. But as we get to yesterday, to me, the beginning of the day and the end of the day were the two most important parts to where we can really learn something about what's going on in this trial. What is the vibe inside that courtroom? And we can learn from that. And even if you think as a lawyer that the indications you're getting from the jury, from the judge, we read the jury. We're not always right, and we don't put all our eggs in that basket as a trial lawyer. Either side, doesn't matter. They read the jury. You pick up on what the jury thinks, what they like, what they don't like. Some jurors are very stoic. Other ones can't control their emotions as much, or they're writing a lot more during certain witnesses, or crossing things out, or flipping back in their notes while you're questioning a witness. And you can really learn a lot. We talked about reports and Ted Daniel in my discussion with him. If you guys haven't watched it, go check it out on Boston 25. But he said that it was very obvious that a juror or some jurors would either laugh or give some indication that when the red solo cups are brought up, especially on cross, jurors would have a reaction. And it was noticeable enough to where the judge felt it was necessary at the beginning of the day today, yesterday, she made a comment, which I'll tell you, judges notice jurors do things from time to time. You don't want to make a juror feel uncomfortable. You definitely don't want to make a juror feel like they're wrong for feeling a certain type of way about a witness. And I have talked to judges about that at sidebar. Be like, Judge, if they're not finding this witness credible and they're, rolling their eyes or whatever it may be, I'm going to object to you telling them not to do that. Now, if they're doing something that's distracting, that could affect other jurors, or that is disrespectful to people in the courtroom, that's different. So we'll listen to see what Judge Cannoni says to the jury right at the beginning of the day today.
To ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? I have one other important instruction for you folks, and it's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk, don't make any facial expressions, no muttering under your breath, no audible noises, because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you don't do that. And out of respect to the lawyers who worked so hard to get this case before. Okay, thank you very much. With that, Mr. Brennan?
What I thought was interesting there, I picked up on a couple things. So somebody said, I can't understand why she didn't just have the jurors or bailiff court officer speak to the jurors in the jury room, not in open court. Well, I think if you're going to talk to them, this is the way to do it. Let it be on the record in open court so there's no discussion about what did the bailiff actually say. Did he say, sit down and shut up? Did he say, you better not laugh at a cop? Did he say, whatever? And then you can start to, oh no, we don't know what happened behind closed doors. One juror felt like he was mean. One juror felt like he was nice. You don't want that. This is what you want. So if she's going to say something to him, I don't have a problem with her doing it in open court. I also don't think she was overly mean. She didn't just say, don't make facial expressions. She kind of couched it in a sandwich of other things to do. So whatever, it is what it is. But what it tells me is it's very noticeable in court what was going on. But what it also tells me is while it was noticeable, it did not rise to the level to strike that juror. And I put up another comment where somebody's like, my money is on that juror doesn't end up deliberating. I am very interested to see if that is the case. And I just, to me, that just seems so unbelievably stupid if you're really going to try to do something like that. And especially when people already have thought that may have happened in the first trial. There was something else I wanted to bring up about what she said. Oh, another thing, if you notice, she said, be respectful and don't do this out of respect for your other jurors and the lawyers in the courtroom who have worked so hard to prepare this case and get this case here. And I say lawyers work hard. Trial lawyers come here. It's incredibly stressful. It's incredibly difficult. So kudos for Judge Cannoni recognizing their hard work. But we don't really care about being disrespected, right? We're disrespected every day. I'll be disrespected during my own video on my own YouTube channel here. And that's what's going to happen. Do you know what we care about? Have some respect for my client, right? Have some respect for the victims if you're the prosecutor in this case, or the defense in this case. Have some respect to the victims. If you're the prosecutor, have some respect for the witnesses. Law enforcement, former military, serving our country, right? If you're the prosecutor, you believe that they're honorable people with honor and integrity, right? And that's what they're here for. So have some respect for the people whose lives are involved in this case. Lawyers are doing a job. So of course, yes, have respect for lawyers, fine. But she didn't even mention the victims, the person whose life is on the line here, who's on trial, the accused, or the witnesses who are supposed to just come here without a dog in the fight and just answer questions. But she didn't say any of that, which I was like, that was something that stuck out to me. Okay. Also, I've had people say, don't you think that's so disrespectful that a juror would do that? As I've said in every case that we follow, we sometimes don't like how a jury votes. We don't like what a jury thinks is important. We don't like how a jury may connect dots or think about things or maybe misunderstand the law or whatever. Didn't speak up enough, spoke up too much. I usually like to give jurors the benefit of the doubt. They're human beings thrown into a situation they're not trained for. And we're all listening to this for a second time. If I go back to my reaction the first time I heard they used red Solo cups in evidence collection, I probably had the same reaction. It's unbelievable. And I'm glad the jurors aren't expecting this stuff. They're not like, oh, yeah, we knew that was coming. No big deal. We knew that was coming. No big deal. I'm glad they're taking it seriously and they're like, no way, this is not how it is supposed to be. They have emotions. They realize, try not to be a distraction, and it is what it is. Okay. We're going to play now. They have another clip of Karen Reed, and I found this to be interesting. I don't medically know. Maybe you need an expert to explain the importance of this, but I found it to be interesting for a couple legal reasons as a lawyer that I've heard argued in this case.
And your first witness, please.
Or if I could begin by offering a stipulation that's agreed to between the parties.
Okay, can we turn the AC?
Yeah, I forgot. A very important stipulation before we get to that clip that all of you guys were wondering about, and a lot of people were speculating about who this was. Let's listen to this stipulation.
Down, please. Thank you. Yes.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
So somebody before he reads the stipulation was saying, that Judge Cannoni was trying to blame the jury for the a-hole comment. I did not know that, but that makes kind of more sense about what she was saying. That to me would have been, if you can actually prove a juror said that, that's more problematic. And if I was the lawyer and they said that about me or maybe my witness, if they were on the stand, I would ask them to be struck. Yeah, see, I don't know. Some people are saying, I don't know. And that's the point. Just like I said with this picture, I don't know. I don't want to go too far down the road when I don't know. There are a lot of bald cops in Canton, a lot of bald cops in Massachusetts. So I'm not going to jump to conclusion. I'm going to wait for the defense to tell me that's Proctor, isn't it? And guess what? It's not. The defense even agrees. Here's the stipulation.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Reed, the defendant in the above captioned matter. Both parties respectfully stipulate to the following. The two Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scortibello, on January 31st, 2022, were Trooper Keefe and Trooper Watson. Former Trooper Michael Proctor was not present.
They even said former Trooper Michael Proctor, and they made Brennan Reed, former Trooper Michael Proctor, was not present. And Sarah Jones, I don't know if you were like half kidding when you said this. Regardless, it doesn't matter. There are people that will truly believe this still, and maybe even a juror, right? Except for, I don't know if a juror knows what Michael Proctor looks like. So maybe not. But this is a good indication and illustration that sometimes you can get hit in the face with evidence and still not believe it. The defense, Karen Reed, can say this and you still don't believe it. That happens sometimes. Even that happens sometimes with jurors. We're like, wait a second. The other side even admitted this, but you didn't agree. And that happens sometimes. I'm telling you, you guys can say whatever you want. I'm just bringing research to the table of cases I've had, cases I've seen here and we've watched together and heard from jurors. Sometimes it happens just like that. And guess what? Karen Reed's clip we're about to listen to, another part and piece of evidence that I think people that believe Karen Reed is innocent are going to say, I don't even agree with that. I still think it's evidence of a fist fight. Let's listen to her clip that they're going to play.
Thank you.
And
Yes, thank you.
with that, Your Honor, I'd like to introduce and play clip number 21.
Okay. Oh, turn the AC off. Hold on 1 second, please. I just want that. Can the jurors hear better with that on?
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
I found that to be odd. And again, once again, why is she giving these details? Right? I didn't watch all these interviews on purpose because I wanted to see what Hank Brennan was going to pull and use for trial and see it how the jury saw it and then see what the defense can do to give it proper context. But I thought that was so strange. Like, first off, so it's not a cut from a punch. Second off, why is it gushing blood? That doesn't make sense for the Commonwealth's case, right? So why would Hank Brennan play that except to show that it wasn't a fist fight? It's glass, not plastic. There was no broken, like her window didn't shatter on the car. But if he's holding a cocktail glass and she hits him, maybe the cocktail glass gets in the nose. I just don't know. I don't see how it helps her. I'm sorry. I don't see how it helps him, Hank Brennan. But I also think it's strange for them to keep asking questions like, in a fist fight. And I noticed they've used, this is consistent with a fist fight. And I've noticed they've used words like altercation, things like that. So I thought that was just another interesting clip. And how is the jury going to take it? You guys let me know in the chat. What did you take from that clip from Karen Reed? Because I always want to know. It's the Commonwealth's case. When it's a Commonwealth witness, what did the Commonwealth prove with that witness? For this clip, what did the Commonwealth use with that clip? But again, I still hate the detail she gave. I came from the left side, which is where the street is. And I noticed it perched like a splinter. It's like, You were frantic, fanatic, losing your mind, saying all sorts of things. I think it's better to be like, I just don't remember the details. And I say I think that's better. I think that's based on the testimony. That seems consistent, but I don't know. I don't know. Auntie Candy said, isn't the morgue an authorized area? They should be checking and verifying credentials, ID to enter, like the key cards for the station. Does the log indeed have false names? That's certainly not a good look and alarming. And again, chat, go crazy. Talk about what you want to talk about. If you guys want to, still believe that's Proctor and there's something nefarious going on there, if there was even a sniff of a chance that that was Michael Proctor, do you believe that these defense lawyers that we've watched fight tooth and nail for every inch in this trial, are going to stand up in court and stipulate to something that says that is not Michael Proctor? I just won't believe that. I am going to believe that if everybody agrees, including all the lawyers in that room who don't want to agree about anything, then I'm going to go with that too. I could be wrong, right? I could still be wrong. That's where my head's going to go. Okay. Then we get the forensic scientist who talks about John O'Keefe's blood's on this, blood's on that, DNA, whatever. None of it was surprising. Yannetti's cross is basically like, you don't say. John O'Keefe's DNA is on his own clothes? And that Lexus is John O'Keefe's girlfriend's car, right? We know he was inside that car at least that night, and probably other nights. That's reasonable to think, right? And then he also, of course, gets in. Who did this person send their reports to? Oh, yeah, that's right. Michael Proctor. If you can say Proctor's name in cross-examination, it gets you points. You further your theory as the defense, and he was able to do that. And he also got into the fact that just about every single one had multiple contributors, at least two other unknown people, many times males. So for the defense's fight theory, it leaves the door open. It does not eliminate the reasonable doubt. So, and by the way, Lally did the direct on this witness, and I wanted to play a little snip from Lally's redirect. Just not a great redirect here, right? And something you'll notice on direct, some of the Commonwealth witnesses are very prepared and they're going through it. Many of them, especially the ones that are truly unbiased, have a pretty easy cross. Like this guy was like, yep, not a surprise. Yep. Whatever, answering the questions appropriately. But when the Commonwealth comes and wants to drive their theory home on redirect with questions they have not prepared with the witness, sometimes it gets a little clunky. So let's listen to this redirect and how, after Yannetti was like, so multiple other contributors who could be anybody, you don't know who those people are. And you didn't test the cops and Albert and McCabe's. You didn't compare, right? Listen to how Lally fixes it.
Mr. Porto, based on your training and experience and years of doing DNA testing at the lab, when it comes to samples from items of clothing, is it uncommon or common to have multiple contributors?
That depends. It can happen, but it's possible, yes.
Lally, what he wanted him to say, as a lawyer who's had something like this happen before, so I get it. I'm not saying he's an idiot and it only happens to bad lawyers, but he wanted him to say, oh yeah, that happens all the time. Because especially if it's like a shirt and you've hugged somebody, and I actually think that's the correct answer. This guy didn't give him the correct answer, but it's like, yeah, if he hugged anybody that night, which we see in the videos, arm around a friend, hugging Karen Reed, whatever it may be, right? He probably hugged his kids, his niece and nephew that night or that day with those clothes on. It's like, yeah, I mean, especially with clothes, it's not abnormal to have multiple contributors. But he's like, I mean, I wouldn't say it's always like that, but it's possible, which is not great on redirect when you're trying to come and lessen the blow that just happened on cross.
Is it something that's a complete anomaly?
I wouldn't say so, no.
Now,
well, at least he got him to admit that it wasn't a complete anomaly. Barber said, per Melanie Little, court officer was sworn in by Cannoni to report a note from the jury asking her to stop sustaining so many objections and let witnesses answer the defense questions. These jurors need to be careful, okay? They need to be careful because if during this case, they feel like they're starting to figure out these are bad cops, this was a bad investigation, I can't trust anything they do, they need to not create a situation where the Commonwealth may be able to get them struck right now because they're showing some kind of bias or not following the rules, or they won't follow the law, as we say as lawyers, where if the judge says it can't come in, it can't come in, regardless of what the lawyers are doing. So if you can't follow the law and give your verdict, you're out. Be careful, because you as jurors, you are following the law, you just don't know it. And at the end of the day, if you can't convict because you didn't get those answers that the judge didn't allow you to get, and you don't have enough information and evidence that you feel like the Commonwealth has proved this case beyond a reasonable doubt, the law tells you exactly what to do with that, and it is to vote not guilty. So don't say this better happen or I can't give my verdict. Instead say, you told me you got the highest burden. You welcome the burden, Commonwealth, and you didn't fulfill it. What else we got here? Okay, then we get to Ashley Villier, another lab person. She does the physical match stuff, and she basically explained what pieces do fit together, which ones don't, what the taillight housing looks at the end of the day. So let's listen to some of what she had to say here. So this is basically what it looked like when she put it all together. How much will the jury take from this? I don't know, but we'll hear at least, again, I'm trying to get out. And in my recaps, that's what I try to do. What did the Commonwealth get from this witness? If you guys think other things came out that is good for the Commonwealth, then during cross, bad for the Commonwealth or good for the defense, let me know in the chat and we can talk about that as well.
Correct?
Not items 7-8 and 7-14, but the other ones, yes.
And why not those two?
They didn't fit mechanically with the other pieces.
Ms. Gilman, if I could have 2150. And again, if you could just zoom in a little. And Ms. Villier, what are we looking at in this photograph?
So on the right side was that piece that was just shown. And on the left side is item 3-1.
And lastly, Ms. Gilman, if we could have 2151. Again, if you could zoom in on that item just a little. And Ms. Villier, what are we looking at in this photograph?
So that's that right piece on top of the tail light from the previous photo.
And is this the mechanical fit that you were testifying about earlier with reference to item 3-1, the taillight housing, and all of the various pieces that were found in 34 Fairview, starting with the number 7?
Yes.
Thank you. Ms. Gilman, you can take that down. Ms. Villier, lastly, in reference, did you also receive some debris from John O'Keefe's clothing?
Yes.
And Mr. Officer, we can have the lights back on.
And then this was after we got, how the taillight fit in there. This was then the next important factor that the Commonwealth was able to elicit from this witness. And this is where you get, because again, the debris coming from the clothing is sketchy at best, but Hank Brennan's arguing it. He's going to argue it more. That was a big part of the first trial, I believe. A lot of people saying, how did the plastic and glass get in his clothes if it wasn't hit by a car? The defense has some theories on that in cross, which we're going to listen to, but they at least got this out of this witness to be able to argue it as facts that are in evidence as opposed to outside of evidence. Jojo, great question. I wonder if people are confused what a stipulation is. Does it get explained to the jury what a stipulation is? Yes. Before the first stipulation, the judge reads, a stipulation is an agreement between the parties that you can take as true, something like that. So yes, it is explained to them. That's a great question before the first stipulation is ever read to a jury.
Thank you very much. And what did you find contained within that debris from John O'Keefe's clothing?
So it was 5 different items. So it was debris collected labeled as coming from the clothing. There was mostly debris, some apparent fibers.
Were there any pieces of apparent plastic contained within the debris?
Yes,
Was there dirt contained within the debris?
yes,
And that debris was labeled as an item 17-18.18. Is that correct?
I believe so.
And what is it that you did with the debris from the gray long sleeve shirt and the orange t-shirt?
So those were all packaged in like glassine folds. And I looked through it and documented it.
When you say you documented it, did you look at it under a microscope?
Yes,
So you did an examination under a microscope, is that correct?
yes,
And did you measure some of those items contained within the debris?
yes,
Specifically, did you measure items of apparent clear plastic contained within the debris?
yes.
And what
That is leading. Objection, leading. What did you find in the debris is what she should have to answer, but no objection. And she said it. Pieces of apparent plastic. Now, to me, a lawyer who looks at this stuff legally and sometimes can be too hypercritical, but for some person to take the stand and say apparent plastic was possible in the debris is just not enough for guilt beyond a reasonable doubt. Now, Yanetti's going to get into how that could have possibly gotten there on cross, but I thought the Commonwealth, these are important facts that they needed to get out from a witness, and Lally got it out from this witness.
What did you measure those items to be?
The piece of clear apparent plastic was approximately 1/8 inch by 1/16 inch.
And once you had conducted your preliminary analysis of those items, where did those items go?
I did no further examination on this myself. Christina Hanley might have examined some of these further.
Will we hear from her?
Thank you. I have nothing further.
Mr. Yannetti?
So another smart move by Lally, right? We're looking for it. We found something. You end with that. You end with the taillight piece fitting over the taillight. I did like somebody's comment, like, you really found every single piece in the yard? No little chips came off to where you have just like a little tiny hole on the opposite side? Other people saying, how did it explode from the inside out? All good questions that I truly believe the jury will be asking in this case. And Peter, I cannot believe the judge in her rulings. Frustrating. By the way, it's too funny seeing that bouncy curl behind your left ear as you speak. I actually noticed it when I read your comment here, and I can't control my hair, especially in the morning. It's crazy. It just does its own thing, you know? Okay. The hat just keeps out of my eyes. That's my main goal. All right, let's take a listen to Yannetti's cross here.
Good afternoon.
Good afternoon.
Yes, John Doe, trial practice 101 is don't ask a question you don't know the answer to, but I will tell you it happens. And I'll just speak for myself. Every single trial that ends up happening because you find it, you take the risk, you weigh it in your head. Is it worth it? And most of the times, at least one question, whether it's, you're also not that afraid with your own witness if you don't know the answer because they're not going to crush you probably. But even sometimes with the other witness, you're like, this is just too good. And if they said something that no matter what you might not know what the answer is, but no matter what the answer is, you're going to be able to make it good for you. You can still ask that question, but generally you're correct.
I'd like to first talk fairly briefly about your reconstruction of the taillight to which you've testified. At the outset, by the way, that was item 7-3.1. Am I correct?
Sorry, for which one?
That's the taillight, this 7-3.1. Am I correct?
3-1, I believe.
7-3.
I can't tell if Yannetti is doing this on purpose to make it so confusing because by the way, you guys didn't have to listen. If you just came here and watched it with me, you didn't have to listen to all the numbers that they said during her direct and how long it took her to talk about which piece goes where. We skipped all that for your viewing pleasure. But Yanetti's like 7-3-1. He's also looking over to the jury. So I don't know if he sees the jury writing down the numbers, not laughing, whatever. I don't know. Because I will tell you, it's not just opening statement and closing argument. You can vibe with the jury when you're questioning witnesses. Sometimes you can vibe with the jury.
-1?
The taillight is item 3-1.
Oh, 3-1. I'm so sorry. Okay. With regard to that particular item, your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yeah. Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
I'll allow it. And you were made aware of that?
No.
One.
Olivia P. This is a good comment and could make sense. And I've actually had trials where jurors don't necessarily get along with each other within the jury box. And that's not great. I always hate that because when you have that, you automatically, and neither lawyer does. Like I talked about it with the defense counsel and I was like, that sucks. I hope they can work together to at least get to a verdict. That almost always comes with some kind of compromise verdict. If they like really don't get annoyed at each other. Sometimes you have an overly talkative juror, another one that's quiet and more stoic. Sometimes one that wears emotion on their sleeves like you might have here. So that's a good question. Yes, Jacqueline, yes and no. So I can't remember. I think Hot 96.9, I talked about this a little bit and how we lost so many jurors early on in the first case. But the reason I am surprised just because with this much time, usually you've lost a juror or two. I'm not surprised because of the selection process. If you remember, they would pick a juror. We'd have a report of 10 jurors at the end of a day, but then they'd lose 2 the next day. So a lot of those early on ones that we would have lost, I think we may have just lost them during jury selection, which is great because now hopefully we're home free with enough jurors to make a decision. Yeah, Ashley D, I don't know. I think the Commonwealth simplified it in a way that if a jury didn't want to ask questions, it makes sense. You put the light over the tail light at the end, voila. But there was some unanswered questions as I was listening to it for sure.
Once you reconstructed the tail light, you'll agree with me that it was missing a piece, correct? Or pieces?
There was an empty spot on the overall reconstruction, yes.
Were you ever provided with any pieces of tail light that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from 1 Meadows Ave in Canton?
No.
Were you ever told about a collision at 1 Meadows Ave in Canton?
Sustained.
In any case, you'll agree with me, there was no glass in that tail light at all, correct?
Within the taillight, I classified them as apparent plastic pieces.
There's no.
And so what I think he's getting at there is if the glass ends up on the nose, which the Commonwealth just conveniently played for this line of questioning for the defense, if he's holding the glass in his hand and it's bent, right? We're all trying to piece together exactly what the Commonwealth reconstruction is going to say because none of it really makes sense. But if the taillight hits him here and hits the glass into his face and the glass shatters and ends up on the bumper, wouldn't some glass end up in the taillight too? Wouldn't it be mixed in with some of the taillight pieces? Wouldn't it be, maybe in the debris here? I don't know, but it just doesn't quite fit, to use a little pun with this witness.
No glass as part of the tail light, correct?
It depends on what you call, like the bulbs usually have glass as far as I'm aware.
Those are very, very thin glass though, correct? Those bulbs?
Yes.
All right. Now, your lab received clothing in connection with this case. You've testified to that, correct?
I received the debris labeled as coming from the clothing. I never saw the clothing at all.
Right, but you're aware that your lab received clothing before the debris got to you, correct?
Yes.
And your understanding was that that was John O'Keefe.
And we knew this was coming, right? We knew this was coming about how the clothing got to her. She did not control the chain of custody where the clothing got to her. She doesn't know what it was mixed up with. She doesn't know how other stuff could have been attached to the shirt or gotten on the shirt, not even planted, just bad police work, right? Thank you, Scott. Thank you.
O'Keefe's clothing in which he was found on January 29th of 2022, correct?
It's labeled as coming from him. I'm not sure of the date that it was found.
Okay. You understand the procedure of that goes on at your lab when it receives evidence?
Yes.
And you know that once clothing is brought to your lab, it's given evidence numbers, correct?
Yes.
And then one of your colleagues at the lab handled the clothing and or examined it, correct, before it came to you?
Yes.
And your understanding is that one of your colleagues retrieved debris from those items of clothing and then packaged it in a fold before it got to you, correct?
Yes.
You then open up the fold and you look at the debris, correct?
Yes.
You never saw that debris inside the clothing, correct?
Correct.
And the pieces of clothing that come in are given evidence numbers when your lab receives them, correct?
Yes.
For instance, the orange t-shirt was given or was named item number 7-17,
Yes.
and the gray long sleeve shirt was item 7-18, correct?
Yes.
So again, sometimes you do stuff like this. When we talked about, I think, was it the Gwyneth Paltrow case? No, there was some case where they talked about a summary of like bills or charges or amounts of money. And the jury asked if they could take it back with them. And we've had that asked for our life care planners. We have a chart with how much everything's going to cost. They asked to take it back. They can't. So a lot of times in closing or during a witness, I'll say these numbers slowly, especially if jurors are writing it down. I don't know if that's what he's doing, but sometimes it does happen. M. Medina, I don't mind Yannetti with the glasses on and off. It's definitely a vibe with your comments. I'm catching a vibe with your comments, M. Medina. And Yannetti, it is kind of a stud move, right? When you don't always need the glasses, it gives you a little extra time to think and to prepare what you're going to say. And since we're already kind of off topic here, I want to get to Bruce. Hey, Peter, my wife is falling in love with you. Is it possible to tone down the charm? Thanks. Bruce's wife. This is very important. I need you to listen to me. Bruce is an absolute stud. Okay. Bruce is a stud. He can do so many things I can't do. And you're so lucky to have him. Bruce is an absolute stud. He's A+ husband. All right, here we go. And Deb said, Peter, please read out questions before answering. I will do my best. I've been trying to do that because somebody else did comment that. If you're just listening and you're not watching, you don't see the question. Sometimes I just answer the question. Doing a couple things at once, but I'll do my best to absolutely read the question before I answer.
And your lab is accredited, correct?
Yes.
There is a complete chain of custody from the moment the clothing was brought to the lab to when the debris was removed from the clothing, ultimately to when you're in court today handling the items, correct?
Yes. Our in-lab chain of custody extends from when we receive it to when the submitting agent it is returned to the submitting agency.
Okay. And you have complete confidence that the chain of custody at your lab is effective at making sure that the evidence does not get lost or mixed up or contaminated, right?
I mean, chain of custody is meant to track where a piece of evidence is. The evidence unit also does inventories and audits to make sure that things are where they're supposed to be.
And you have confidence in your.
Yeah, and that's important. I don't know if they were trying to downplay it, but like that's important. Felicia, jurors need someone like you explaining to them. I don't feel like juror instruction in the beginning is enough. By the way, I'm a barber in town of 2,000 people in Illinois and just found out my shear rep listens to you too. It's incredible, Felicia. That's awesome. Tell them I said, what's up? But what I want to say about the first part of your comment. So it's different. And this is something that maybe if you guys have never been on a jury before, you don't understand or you don't get that feeling. I think some people, definitely not all, I'm not trying to say everybody, and you can go ahead and let me know in the chat if you're not one of these people. A lot of people in this chat want to hear what I have to say, like to ask questions, disagree, talk about stuff, and you kind of trust that I'm not a lawyer in this case, and we can talk about it from the outside looking in. Lawyers in the case, when we are trying trials and we have cases, we represent a client. We do our best to explain a lot of this. Obviously, you can't do it exactly how I do it. That wouldn't be proper. But while you're questioning witnesses, in opening statement, in jury selection, and closing argument, we try to do a lot of these explanations. The problem is a lot of jurors look at us like, yeah, right. Yeah, right. You're just doing this for that guilty client you have sitting next to you. Or, yeah, right. You just want to put everybody in jail because you're a prosecutor and you think all cops are great. So a lot of times jurors think with some preconceived notions, and maybe they're hearing these lawyers say some similar things that I'm saying, but they feel like there's some weight behind it that is maybe biased towards one side or the other. So I think sometimes that does happen. It's a very difficult scenario. And I agree with you. We got to find a way to equip jurors even better than we do. And we're constantly trying to improve our rules. So I appreciate the comment, Felicia. And I agree with you. We got to find ways to make it better.
Your lab's chain of custody policies and procedures, correct?
Yes.
But you'll agree that your lab cannot control who handled the clothing before it arrived at your lab, correct?
Yes.
There are times in which crime scene technicians or criminalists from your lab actually participate in the search for evidence at a crime scene, do they not?
Some of the people at the lab are crime scene responders, yes.
There are times when they actually take custody of evidence. Again, I'm talking about people from your lab, professionals. They take custody right from the crime scene and transport that evidence to your lab, correct?
Yes.
In those circumstances, your lab would have a complete chain of custody from discovery to seizure to testing or whatever comparison you're doing until you release the items, correct?
Yes, but the electronic chain of custody doesn't start until that item is entered into our LIMS system at the lab.
Right, but when it's entered in, it would be entered in as having been seized by somebody from your lab, correct? In the hypothetical that I'm giving you.
Yeah, there's an evidence submission form that says that this crime scene responder submitted it to the laboratory.
And the reason Yanetti's bringing this up is because he's like, Proctor definitely wouldn't allow that in this case. He was the one that had to do everything. He was the one that had to put his hands and fingers on everything. Mr. Meat Hook, given the Commonwealth's snarky attitude to date, I would never stipulate anything with them, even if true. Am I just being vengeful? So your question is well-founded, and I think that's how the lawyers think in this case. I'm not stipulating to anything with that guy, which is why this stipulation to me is telling that it's very likely true and correct, because I think they have gotten to that point. Now, why they did it, I don't know. Why they didn't leave it as an open question as a Proctor, I don't know. Maybe it was proven to them that it wasn't, and they were like, yeah, if that's the truth, we'll tell it to the jury, which is how it should be also.
There are other cases, however, when the evidence is brought to your lab by the police, correct?
Yes.
Local departments have access to your lab?
For evidence drop-off, yes.
The state police have access to your lab for evidence drop-off?
Yes.
And in this case, it was not a criminalist or other professional from your lab who seized the clothing and brought it to your lab, correct?
I'm not sure.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes.
Can you testify to the jury about who it was that brought this evidence into the lab?
So you can tell us.
Okay. So submission 7, all the items that are 7- was submitted by Trooper Michael Proctor.
Whoa, was anybody shocked by that? Was anybody surprised? Over an objection. If you're Hank Brennan, don't object there. Or actually, it was Lally, I guess. Don't object there. Just let her say it. Don't object there. We all know it's happening. We all know where this is going. The Ghost of Brian Higgins SIM card. What are your thoughts on the 20-some odd plastic pieces that didn't match her taillight? And you're awesome. Thank you. So I'm thinking maybe those are little clips of pieces that, would shatter if something like this was going to shatter. Or what if you want my honest opinion? Okay, honest opinion. If I was a juror, I probably wouldn't think that much about it unless Yannetti brings it up as a major issue on cross. Like I would kind of get into the groove of the issues are going to be highlighted to me. Now, that's how I see it as a lawyer / juror. Most jurors do exactly what you're doing, where they find things that they think are important, regardless of if we lawyers think it's important. So I think it's a good question. Peter, should the defense file a motion for all and any communication between Aperture and the Commonwealth? I would assume they've gotten that communication already because it is discoverable. But if there was a reason they didn't think they got it, then maybe they would. We will be getting to this conversation very soon.
Were you aware of the date of the incident that gave rise to this case?
Yes.
And what was that date?
January 29th, 2022.
Were you aware that the clothing that you received was seized from the Good Samaritan Hospital that very day?
No.
What date was the clothing brought to your lab?
March 14th, 2022.
So that means that your chain of custody at the lab began on March 14th of 2022, correct?
Yes.
And would you agree with me that was about 6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of 2022, correct?
Correct.
And you have no information.
Pretty wild, right? It's a long time. Why? Why did it take this long for it to get into her chain of custody if she was the one doing this very important work on it, right? Like, why? Why was somebody else controlling all of this, potentially editing? Because, I mean, this witness comes here and just testifies to, this is what I did, and here's how the pieces fit together, and this is what I found in the debris.
And do not know why Michael Proctor waited 6 weeks to bring this clothing to your lab, do you?
Sustained.
Do you know where Michael Proctor stored this clothing during that 6 week period?
No.
Do you know how often he was alone with access to the clothing during that 6 week period?
Sustained.
Do you know if he had access to pieces of red or clear taillight during that 6 week period?
Objection, strike out.
Sustained. Move on, Mr. Yanni.
I think those are fair questions. Like, that's the point, and that's what they're trying to do. And the answer is she has to say, I don't know. So you can't sit there because the chain of custody and the logs are so horrible or non-existent in this case, or as Trooper Buchanan thinks, that's redundant because I can just tell you where it was. It's like, that's not how why would we ever document anything then? All documentation is pretty much by definition redundant, but it's also confirming and making sure that you're doing the right thing, or we can show when you're not or when you're lying. That's the point of it.
You were not present when the clothing was seized, correct?
Correct.
You did not have custody of this clothing from January 29th of 2022 to March 14th of 2022, correct?
Correct.
You do not know what was done with the clothing before it arrived at your lab, correct?
You've covered this, Mr. Yanni. Move on, please.
One last question. You cannot vouch for how the clothing or taillight pieces were handled before they got to your lab, correct?
I cannot.
Anything further, Mr. Lilly, or are you all set?
And that's how he ends his cross. David James, who do you think is more factually innocent, Richard Allen or Karen Reed? It's impossible for me to compare these two because I didn't watch the Richard Allen trial. So it makes it so difficult for me. Melissa, why has every case with a special prosecutor been an absolute disaster? Baldwin's mess, and now Brennan. Loved the coverage. Can we get Andrea on soon? So to the first part of the question, a lot of these are high-profile cases where they select specific special prosecutors where they get a lot of eyes on them, and we just happen to watch them. So that's probably why. Yeah, I definitely want to hang out with Andrea, talk to her soon, pick her brain about this case, see how she's seeing it. It's really hard. Somebody else also asked, juicing recipes. Can you do a show with Melanie Little? She mentioned that she would like to also. Melanie, Andrea, Emily Baker, everybody that is streaming this trial, I can't imagine how tired they are, right? And how long those hours must be and how brutal days must be like yesterday, where even though it was short, it was this kind of testimony with 7-3-1. So it's tough. And it's in case you can't tell, we're coming up on the hour. Hit the like button if you guys haven't already, because surprise, we're going overtime here. We're not going to be finishing in an hour. It's so hard for me to get in everything I need to get in to recap these. And then I've been trying to get my dad's take every week, which I think you guys like and want. So it's been difficult to try to collaborate with people. Like when I had Benro on, he's not streaming daily, but it was the off day when there was no court, and it just happened to work out in our schedules. And me and him from time to time will DM each other on Twitter like, can you believe this? Or what do you think they're doing with that? Or that was bad. So sometimes that happens, and just we happen to be talking when the day opened up, and we decided to jump on and talk about the case. So yes, we will talk to as many people as we can throughout the process, maybe after the process, but the world is our oyster, people. It's not going to stop. We're going to be able to talk about this case. We're going to be able to get different people's opinions and discuss it. So don't you worry about that. Why not force the DA to call that trooper? It was a strategic decision by the defense is all I can say, right? That's really all I can say. Doro, Peter, can the lawyers request to see the numbers go in and request to see them picked for the jurors to not deliberate? Yeah, they can probably say, we want to make sure all this is done appropriately. Can we see that all the numbers are in there? Some judges might not like you questioning their character, but I think that's a reasonable request. I've never had a judge pick an alternate like that. Usually every trial I've had, we know who the alternates are. We pick them as alternates, meaning if we really don't like them, we may not strike this person to get the alternate in because we know they are an alternate. So it's a little different. Alicia, why couldn't we have an Apple employee come and testify about the house-long search? Surely Apple would be the be-all-end-all, expert on their own tech. So it's proprietary. They were talking about how you can't really get it. I don't know that something like this was possible. Heather, nearly half of the plastic pieces found did not match the tail light. Yannetti didn't drive it home hard enough. Rest of plastics not matching appear clear. Didn't ask because they don't know where it came from. And again, this is just me saying, I don't know. I don't know. I can't analyze it because it wasn't dug into enough. We didn't get the details on it, which makes it difficult for me to say, oh, this is why it's really important to the defense's case. It was very clear from Yannetti's cross, he did not feel it was important to his case. So I'm usually not going to jump on that. Doesn't mean jurors won't. Mike Z, huge fan of the channel. Thank you, Mike. Thanks for the great work. What are the various ways the defense can get into the evidence, the Proctor termination letter? So the letter itself is not going to come into evidence. They've already discussed some of the content of the letter with Buchanan. If, and I believe when, the defense calls Proctor, if the Commonwealth does not, they're going to be able to get into a ton of details on it, a ton of the findings. I expect it to be a big part of his cross-examination, and that's how they can appropriately get it into evidence. Judy V, doesn't the note to Beverly Codoni about the sustained objections show the jurors are talking to each other? That could be another problem. I agree, potentially. So I don't know what the note said. They didn't read it on the record, at least that I saw. So it's hard for me to really speculate and tell you what it means or what we can learn, but a lot can come depending on the details of the note. Ashley D, thoughts on why the defense didn't confirm the glass doesn't match the glass found next to OJO. Trial 1 they did. How biased is Bev? Biased Bev now 1 to 10. I don't know, Ashley, and thank you for clarifying this, because sometimes I can't tell what my memory is from trial 1 or trial 2. The jurors aren't going to have that issue, but I thought they did confirm that it was not the same glass as well the first trial, and I don't remember that coming out this trial. I don't know. That was big for me in the first case. Like, where's the glass from? Is it from a glass inside the house? Is it planted glass? Like, what is it? Was he wearing glasses? Would that be glass? I don't even know. Probably plasticky, right? Different type of glass. How biased is biased Bev? Now let's wait until we get to her ruling here, which is coming very soon. Britt Kormeyer, if the jury has an issue with the sustained objections due to it not being clear to them, why is it invalid? I'm not saying it's invalid. What I'm saying is you take an oath as a juror in the beginning of the case to follow the law. That means, in this example we give all the time, if you think marijuana, especially back in the day, if you think marijuana use should not be illegal, or should be legal. And I tell you it's not, and I prove this guy was smoking marijuana, will you be able to convict? And people are like, no, I can't. I just don't think it should be illegal. That is not following the law. And that's a similar issue here. If you think you have a right to know the answer to that question and you have to listen to that question, and the rule of law says you can't get that information because it's not relevant or it's not reliable, like she said, he said, I said, uncle's cousin's brother said, is not reliable, but you think you want to know what the cousin's uncle brother said, it's not appropriate and you can't make your decision based off that. But if you think you need more information and you didn't get it, well, that's a reasonable doubt potentially. Is it hearsay, leading speculation? The jury doesn't know this due to the way Bev does objections. The jury is not supposed to consider the reason for objection or the reason the judge did not allow it in. That is not something that's relevant for the jury to consider. Lavelle, check out Truth Revealed podcast. Sergio De Niro is a seasoned deception detection expert. That's so funny because one of the officers said they were skilled in was it deception detection, something like that? With over 20 years of extensive expertise in federal safety, security, and intelligence operations, he's been analyzing the Karen Reed witnesses. It is eye-opening. Melissa from the Get Up crew. What's up, Melissa? And broken-hearted Celtics fan, yes. And I missed my bet because by 1 3-pointer, I thought Jaylen Brown would hit 4 threes. But I did have a feeling the Celtics may lose. Who you got, Pacers or Knicks? Thanks for everything. I guess I'll roll with the Knicks. They feel hot. They feel like the team with the higher upside. They also feel like the team, if I'm going to say the NBA's rigged, which I'm not going to say that, they would want the Knicks to be in the championship because like a Pacers OKC championship might not get a lot of eyeballs, right? I think the Knicks will get more eyeballs. So that's what I'm going with. All right, let's get back here to court.
I'm not cribbing it.
No. Very. Mr. Lear, there is a separate evidence unit contained within the Massachusetts State Police Crime Laboratory, correct?
Correct.
And so what does Lally decide to focus on his redirect? What did he find important? What did he feel like he needed to rehabilitate from Yannetti's cross? It's always very telling. Think about that. Be like, so what did Yannetti think was important? Because that's what he's going to focus on in cross. Now, what does Lally think was important from the cross? That's what he's going to focus on in redirect.
And fair to say you have absolutely nothing to do with that, correct?
I'm not a part of that unit.
And so your responsibility as far as chain of custody is concerned is from when you retrieve the item during your analysis and then when you return the item to the evidence unit, correct?
Correct.
And from that analysis that you performed, you found that there were 10 different items, starting with the number 7, that were a mechanical fit to 3-1, the taillight housing from the defendant's vehicle, correct?
If it's 10 items, I don't have, I can count them.
Okay. As far as all those items beginning with 7 that you went through or elucidated on your direct examination, each of those were a mechanical fit to each other and then to the taillight housing in 3-1.
The pieces that were previously stated, yes.
Nothing further.
All right, let's finish if you are. Go ahead, you're all set. All right, so jurors,
So now she's going to make another announcement to the jurors.
that is it for today. I am told when I spoke with counsel earlier that we are still on track. I have to tell you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be extra careful with your social media use. And also, I just want to remind you, next week, Thursday is a half day and Friday is a day off. All right, so we'll see you on Monday.
Please rise for the jury.
Let's see, I got this.
All right. So before we get to the arguments and discussion about what's going to happen with the ARCA witnesses, there was a couple questions I wanted to answer here. Patty, Massachusetts resident, how likely is it that jurors know about the Birchmore case? It just depends on how much they're following the news and those types of cases. I would assume it's all over the place. up in that area. Which case would you rather defend, Karen Reed or Richard Allen? Not close, Karen Reed. There's so much to work with here. And because of all the confessions with Richard Allen, no matter how good of a job his defense team did, it's always difficult to overcome that. Always difficult. Disney. Hey, good looking. Do you think the jurors are picking up Bev's behaviors? She is very strict with the defense. Would she face consequences eventually? I don't know. We'll see if there are any complaints made and stuff. And again, I don't know what the jurors do pick up on and don't. All I can say is my research and experience is most jurors like the judges. With the Commonwealth's expert getting to rebut. Okay, hold on. Sorry, I want to hold that one. Azam, hit like and subscribe, please. 500K, fast approaching. Yes, everybody watching this video subscribes. We could get to 500K ASAP. ASAP. How does glass eliminate a fight? Also, it's true. It doesn't. It doesn't. I just feel like they've asked a lot of witnesses. Those injuries could be consistent with a fight. So maybe you're right. John Doe, please consider helping law students understand practical skills. I went to law school graduated without knowing how to prepare a petition. Trial advocacy started with opening statements. I agree and I understand. I don't ever see myself doing that, especially with this channel now, how much I enjoy this format and being able to also control my own schedule and be able to do it whenever I want to on topics that you guys ask about that I find interesting. It'd be really hard to be put in a box of a trial advocacy professor. Aaron Blackman, but some are great at that. Some are great at that. It's just not for me. If Mr. Iannetti is a local lawyer, maybe he's used to the antics of Judge Bev and Brennan. Maybe he's able to reassure the rest of the defense team that things will be okay. Or do you think he's as concerned as the rest of us? There have been plenty of trials where I'll just tell you honestly, where I felt like judges were so unfair against me. It's horrible. I'm on the phone with appellate counsel, like, we're going to appeal all this stuff. And then the verdict ended up being great for us. There are cases where internally I've been going, you can't do it outwardly and you can't make those comments or let the jury know. But I have had that feeling in many trials. So that might be what they're having here. Mrs. Parks in the house, or Pakistan, I think I've said. Peter, if Proctor wasn't at the autopsy, it's almost better. Yes. The ME could not rule this a homicide. Proctor is never associated with anything good. No Proctor at ME equals good results for Karen. Thoughts? Well, there's evidence that Proctor was pushing this ME and giving her information to try to get her there and didn't accomplish the goal. And also, from my perspective, one of the reasons maybe the defense didn't push harder on this is Keefe was wrong. Did he lie? Was he just incorrect? Is it just another inconsistency? He was wrong. That picture proves he was wrong, whether it was Proctor or whoever else, like Watson or whatever the guy's name was. Scott, how do you think this case would vary under different judges? Melly, Baldwin, Koberger, Allen. Certain judges, I think, may have thrown this case out. Certain judges may have thrown out counts 1 and 3. Certain judges would absolutely have called the shots differently in what we're about to get into. I think it would be very different depending on the judge. Why can't the lawyers say the words reasonable doubt when inquiring a witness? That enters the province of the jury, right? The jury has to determine if there's a reasonable doubt. Using that language when it comes to you had a reasonable doubt as to where this bag was is potentially borderline entering the province of the jury, asking, is that a reasonable doubt? Are you telling the juror to vote not guilty? That's probably why. David said, last comment, I feel the defense could say nothing in this case, and as a juror, I could still not convict her. Well, the rule of law says the defense can sit there and say nothing, and still sometimes it is not guilty. Was one more. All right. Let's get to now these discussions about the changed time, what the last arguments are, and what the decision for Judge Cannone. It's also, we're over an hour. Hit the like button, folks, if you guys haven't already.
So before we recess, I appreciate that counsel provided me with the information. Mr. Leslie, I got the 2 reports that you had that were incorporated and what the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that
The defendant has not persuaded me of undue surprise or unfair prejudice by this information.
So her first finding is that the defense has not proved to her undue surprise. How much more surprised could they have been than telling you in the middle of trial the times have all changed? Now, unfair prejudice to me is one within the judicial discretion. We're going to talk a lot about that. I think it's prejudicial. I think it's difficult, but I also think that it's almost good for the defense. And this is creating more of an opportunity just to show exactly how this went for the defense. We'll get into that. So maybe that's what she's thinking when she thinks it's not unduly prejudicial, but pretty wild.
And I don't find that there's delayed disclosure. Of course.
How do you not find there's delayed disclosure? To me, the middle of trial to change how you're going to set up your conclusions as an expert, it doesn't get any more delayed than that to disclose something to the defense. Now, if I'm trying to put my other hat on, which you guys know I like to do, and see it from the other side and try to come up with a way why this makes sense, Hank Brennan has said these are the discrepancies or the time discrepancies or variances we've been talking about the whole time. Nothing has changed. It's always been up or down this many seconds. So this is still within what we've already disclosed, and none of the underlying information, none of the underlying evidence or phone downloads or anything like that, none of that has changed. So all of this has already been disclosed to the defense, and therefore it is not a new disclosure. They already knew about all this stuff. It's just a different conclusion at the end, which just a different conclusion, in my opinion, is material, but that's the way to see it from the other side. I like to try to put myself in their shoes, even when I disagree.
All of this is ample game for cross-examination, certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you.
So that was interesting when she said violation of the sequestration order. I didn't catch that the first time through. I thought maybe the experts were allowed to watch and listen because I know there was some discussion about that. By the way, it's also hard when they do so much sidebar and they're making decisions at sidebar we don't know about. And then stuff happens in the trial where you're like, wait a second, but they could be making decisions, or there could be arguments we think are still open, but they're not because they've closed the loop on sidebar, but we don't know that. So she just said potential violations of the sequestration order. And she also said ample use for cross. I'm going to let her finish her thought on that. And then I'm going to give you some specific examples of what I would do on cross if I was a lessee.
You a lot of leeway with that, Mr. For report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct...
So Jay Coop said, Peter, what would you do if this was your client and you see this? I'm about to explain it. So she's explaining, I'm going to back it up because I want to kind of keep this going together, but she's explaining, you've been doing such a great job in cross. This is like when you hold it against the lawyer for being good. This is what she's going to kind of say. Like, again, she's really telling him, kind of like she told Brandon with ARCA, I'm really going to give you a lot of leeway with cross, and I think you're going to do a great job.
Facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding...
Okay, so now before we get to the last part, which is potentially more unbelievable than this, I kind of thought she was going to allow them to do this. Everybody asked, and I was like, yeah, I think she's going to let them change the time. What she better not do, we'll hold till later. Can the defense get the missing tailing piece in with ARCA? Potentially, I don't think they're going to. Maureen, great point. How can you say it wasn't surprised when Hank Brennan himself said he was surprised, right? We all know the lawyers watch, but do the jurors watch these recaps as well? I hope not. If you're a juror, stop watching, please. Do not watch. Just watch the trial. Make your decisions based on the evidence you see at trial. So cross-examination and what he can do in cross-examination. Let's talk about that for a second. So we have heard Alessi cross multiple witnesses, and we heard him make his argument about why this is such a big deal. He said these seconds are incredibly important. So at the very least, there should be a section on cross like this, where Alessi says, you gave us a report on this date, and let's go through that report. And I would lock that man in on his report, his original report that had the 12:31 and change time. So at the time, 12:31 and change is when you said the impact happened. So you had this evidence, you had that evidence, you had the phone downloads, you knew what all these people were going to testify to, you had Whiffin's reports, and this was your conclusion. And let him quibble and wiggle all he wants, but you say, we are looking at this date in this report. I'll let you talk about what your second report or fifth report, whatever it ends up being. We'll talk about that in a second. We will get there, sir. But I want to talk about your report dated, whatever date it was originally. So the whole way, you were hired in October, and this trial started on April 22nd, and your expert opinion and conclusion was 12:31 and change. And that was your conclusion when I crossed and my team crossed witness after witness. Isn't that correct? In fact, Mr. Whiffin, who was a big part of what you did in your report, the underlying data he pulled, and by the way, if you remember, Mr. Whiffin said, you can't just pull the data, you have to have somebody analyze it and tell you what it actually says. And that's what he did, right? And you relied on that. And I cross-examined Ian Whiffin on April 28th, I think. On April 28th, he'll have the exact date. And you realized when Whiffin was on the stand, you're wrong, right? You have the wrong time in your report, 12:31 and some change. But you didn't change it then. You didn't send over a report on April 28th, did you? Then when Mr. Jackson crossed Jen McCabe about lots of stuff that you want to come here and say, this data is good, this one's not, here's the time, whatever it is, how it lines up in your timeline. She was on the stand, April 30th to May 2nd for a couple days. And at that time, April 30th through May 2nd, your opinion, your conclusion was 12:31 and some change, right? And you didn't change your report on that day. You didn't turn it in on that day. Then Jessica Hyde was on the stand and she was cross-examined on May 7th. Another tech expert, whatever, went through some of the similar stuff with Ian Whiffin. And Yuri Buchanan, the person the Commonwealth wants to basically say is the lead detective on this case, the lead investigator on this case, he started testifying on May 8th. That's when you decided to produce a new report and change. You would agree it's a material change, right? He has to agree. The time of this collision, incident, death, whatever you want to call it, phone stops forever. That's important, right? That's important to the accident reconstruction, right? That's important with the Lexus data, the cell phone data, the health data, the testimony of the witnesses. And after all these people testified, after cross-examination of all these witnesses proved that you were wrong at 12:31, you decided to change the time to 12:32 and some change, which is what I've been saying in all of my questions is the true time. Isn't that correct? You realized, and if he says, no, I didn't listen to that witness, or no, I didn't hear that cross-examination, or no, that's not why I changed it. I had this other reason to change it. You still present the timeline because the timeline can't be broken. Dr. Wolf said Bev won't let this in. I think she just indicated she will let it in. And if she doesn't let it in, that's a huge appellate issue. You have to let in this entire timeline. Let them object. Let them object all they want to. I don't even care. How do you look like a reliable witness during that cross? It just so happened the day after Jessica Hyde and the day Buchanan gets on the stand and starts testifying about all this stuff, you give a new report. And guess what? That report wasn't even turned over to us until May 11th. 3 days after or 4 days after Buchanan is on the stand, starting on the stand. Weeks after Whiffin got cross-examined. Weeks after I basically proved through these witnesses that you were wrong. Now that's argumentative. But I think she's going to give him some leeway and be like, Judge, I need to prove the timeline of when this guy changed his time to the jury so they fully understand what's happened here. I would put, and if she didn't let me do it, I would ask her to send the jury out and let me proffer the cross-examination I think is necessary to prove just how bad this is. I would make it as broad and brutal as I possibly can. This would be a huge chunk of my cross. It may be the beginning of my cross if I'm Alessi. Then you go into everything you plan to cross-examine him on anyways, because you realize Mr. Alessi, very prepared. He's already got a cross prepared for this guy. He's already worked with ARCA to cross this guy. But this is all brand new. So I'd probably start with it personally. And I think that should be a huge part of the cross-examination. And I would say you changed your report on May 11th because you knew you were wrong based on how the evidence came out in this trial. Isn't that right? Because you already had all this underlying information. You already had all these details and you got it wrong until somebody had to tell you. Oof. I mean, that's brutal. To me, that's almost better cross than he was going to get. The Ghost of Brian Higgins SIM card. During his opening, Brandon said, I'm going to show you why Waze is the best for showing time. Isn't this time change in time really detrimental? The defense will surely blast this change to the jury. Will the defense be able to cross on the timeline change? Absolutely, in my opinion, based on what Judge Cannoni just ruled. Joe Ellen. Last year, the Commonwealth alleged the time Karen Reed struck John O'Keefe has now changed 4 separate times. 12:45 first theory, 12:30 second theory, 12:31:38 third theory, now 12:32:16 the new theory. Yeah, Lally was all over the place. I mean, that timeline was horrible. And then it just kind of felt like he was saying 12:30-ish or between 12:30 and 12:45. Hold on, sorry. I'm going to hold that question still. Cannoni, Mr. Alessi, what remedy can I offer you for allowing the Commonwealth to change the expert's theory? Alessi, Ave voir dire. Yeah, no. And yeah, I don't know if we heard that yet, but she's not even going to let him voir dire the witness. I think she should let him. It would let him perfect that cross that I just did. It would let him perfect those details and figure out what is that witness going to say, because if he's going to disagree or lie or say no or admit to violating sequestration or not admit to it, which could be unbelievable, then Alessi could be more prepared. Azam, hey, Peter, it would be cool if you could get Yannetti or AJ or Alessi or all 3 on your channel like you did with Mark Eiglarsh. That would be crazy. Could you imagine all 3, what that would be like? We'll see. We'll see. They're going to be busy. They're going to be doing interviews after, probably regardless of what the verdict is. They probably won't have time for it. We'll see. We'll see if we can make it happen. Belinda, happy Saturday, Peter. Can you please explain why a M charge can be brought if the coroner's report doesn't say I'm baffled? Yes, people have asked this question, Belinda, and the ME does not make a determination of guilt or innocence. They just make a homicide determination they weren't able to, which can be a reasonable doubt, but they have a completely different function than the jury. The jury is here to make this decision. Why didn't either side hire a blood pattern analyst? I don't know if there was enough to even get use out of it, right? Where maybe it's because they collected the blood in the red Solo cups. Peter, how do you feel about so many half days or days off as a juror? I'd want this case over as soon as possible. Very occasional would be nice. Yeah, I agree. It's not great. Doesn't make you feel great. Some are unavoidable and you just can't do anything about it, but I would get annoyed. Britt, follow up to the first super chat. I understand when you say it is out, so it is out. I think this was the question about jurors being frustrated or wanting to know answers on questions that the objections are sustained. For whatever reason. However, juries are humans, I agree. And if they don't understand the reason, they may come up with their own, like this judge's bias. I agree. And that's why we do everything we can as lawyers and judges to try and dispel anything they shouldn't be thinking, but we're not perfect at it. And that's proven every time a juror is interviewed. Can they bring up this is the 5th time the Commonwealth has changed their theory? Not with this witness. This witness, they can only talk about his change of theory. I think she's going to sustain the objections, Mo. I hope she doesn't, but again, we'll see. GoldenEye, best SNES game ever? Probably. MKCT, thank you for gifting 5 memberships. Bethany, so are you saying this new change is going to be a problem forever, the Commonwealth too? I think so. I think it's a major problem for them. More of a problem for the Commonwealth. How is this helpful to the Commonwealth case other than to change so late in the trial? And we're going to find out, right? Because I want to see how it comes out, but I think it's more helpful for the Commonwealth because it's going to line up with the other evidence and their other experts they've already presented, like Ian Whiffen. It's going to be a problem for the Commonwealth because of all this additional cross, and because the later you tick that collision, the harder it is for Karen Read to get home to John O'Keefe's house and connect to his Wi-Fi by 12:36. Nikki, can you imagine if one of your cases went viral like this? I don't know how the attorneys do it. It is a very different experience. It's an experience not many attorneys have, and when they have their first one, they learn how to deal with it, right? This is not normal. To have this many people have this many opinions and strong opinions about a case is not normal. Late to this party, still did not watch yesterday yet. Wanted to send support. I'm scared, LOL. Happy Saturday to you and the family today and our chat. Same. Thank you, reality. And hey, it was a shorter day. Not the most exciting day, but it was a shorter day. Brittany, Hank really ticked me off yesterday when he said his expert already found so many issues with Arca's report. So rude, dishonest, and dirty, in my opinion. Oh, yeah. He loves to be one of those things like, oh, if you guys only knew. Somebody told me. I can't tell you who told me. He seems like one of those guys with this stuff. Do you believe she'll allow the defense to cross on the changing timeline? She said she would. So I only have to go by her word. And she will hear them on recalls. Do you think they should recall? Only if it's absolutely necessary. Only if it's absolutely necessary. Amanda, did the prosecution mention 1231 in opening? I hope the defense calls it out. I can't remember specifically what they said, but I would try to find ways to put that in the argument. Like the Commonwealth's theory in opening was this: objection. I may ask that question. I may ask it. That might be sustained. Maybe see Brennan's opening again on the day off. Maybe I'll take a look at it. Is this Canoni's payback for Arca? It shouldn't be, but I mean, this absolutely shouldn't be. Allowing what's about to happen, I think, it is payback for Arca, what she's going to do. This should not be. I cringe every time I hear Judge Canoni say, I will hear you on that, when that she really means I'll hear you on that and then deny it. It's almost like when you tell your kids maybe on something you don't want to do. Maybe, but you know it means no. But the way she does it and the reason she does it, and I did want to mention that, so thank you so much, Ugo Monk, for bringing this up, because I forgot to mention it when I heard her say it. It popped into my head and then it quickly left. Why does she do that? Because it allows the remedy, it's properly within her discretion, and it will help on appeal. That she allowed this remedy, she allowed them to fix it. If they wanted to have more time or if they wanted to call more witnesses, she was going to allow it. That is a proper remedy. That is a less restrictive or harsh remedy than not allowing this witness to change his testimony. So from my perspective, I think Judge Canoni is doing what she should do, meaning at least when she says no, she'll say, if it gets worse, I'll give you another chance. And the appellate court is probably going to consider that more substantive and important than maybe some people in the chat do. No way Bev grants dismissal after the state claim. No way. No way. Peter, do you think the attorney should make it clear to the jurors they can send questions they have during deliberations? Thank you to your channel. So that depends on the jurisdiction. Some jurisdictions don't want to welcome questions. Like in Florida, they always are like, we don't want them to ask for readbacks. So don't say anything that could let them ask for readbacks. So I don't know. Whatever's allowable in their jurisdiction, I would probably do. Doesn't he only change his testimony based on what ARCA stated in their report? I think there's Commonwealth evidence that doesn't agree with the 1231 timeline. But again, let's wait and see how this is all fleshed out when they're on the stand. The ME gave perfect closing for the defense. The experienced forensic pathologist evaluated John O'Keefe's body, knew about the alleged confession, taillight pieces, spoke to the cops, and still felt there was reasonable doubt to not say he hit a car. I think that would be objection, facts not in evidence, because that wasn't allowed to be asked her. Still was not able to determine that this was even a homicide, which is not as high of a burden as you guys have. That's what I would go to. What are your thoughts on the jury being able to ask questions? I think every jurisdiction should allow it. I 100% agree. I think they should be allowed to. I love it. I want to learn more information, not less. Should the defense move for a mistrial on the record? No, I don't think they should based on this personally. All right. Now let's hear what I found to be the worst call in all. That to me, if I was in trial, that's the answer I probably would have expected. I would have been pissed. I would have been pounding the table, but I probably would have expected the judge to allow that. This I would not have thought she would allow.
You need to recall them. I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify.
Let's see how much Dr. Welcher could go through. To leave that open to be like, that's like me telling Maverick, hey, Maverick, I want you to run 20 laps around our house, but you don't have to do it. Like, we'll see how many laps you've done in 3 days. He's going to say, I've done no laps in 3 days. So it's like, if you tell Dr. Welcher to see how much you can get through, and if you can't get through it, then I'll give some other remedy. It's like, don't get through any of it. Let's see what the other remedy is.
And the Commonwealth's case in chief next week or so, Mr. Brennan?
Hopefully next week, if not
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies, the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right. So
I want to clarify something here because words are important. New information. So what he's asking for is for his experts to be able to get up a second time in rebuttal. But if you remember, rebuttal is only to testify about stuff that came out during the defense's case in chief that you have not already addressed in your case in chief to respond to. It is very limited. But she's not saying that. She's not just saying what comes out in the case, in the defense's case in chief, because that may be thought of as new information, but it's not. What she means is any of the new testing, new opinions, new information ARCA has put in since they've been retained, and they only had 4 or 5 weeks to do it. They did it, and Welcher has had that information now for a week or something. And again, he's going to have it for another week before he takes the stand, or the Commonwealth can delay calling him or ask for an additional week for him to prep. There are other remedies to where he can prepare for this new information that is part of ARCA's reports they're going to testify to in the defense's case in chief, and that's when he should testify to it. To allow him to split his testimony, have more time to prepare, be able to listen to ARCA, and then come back with not just responding to what ARCA said, but also to potentially condemn the way they did certain testing. Why he didn't. Potentially, he could do new testing and more testing to respond to their testing after they've already testified. And if this is confusing, it's because this is not how it should be. This is totally unfair. This is giving them 2 bites at the apple. This should not be allowed. If I was the defense, I'd be like, Judge, give him another week if he needs a week. Give him time to prepare as he needs to. Let him come and do his testimony. And if they're going to have a rebuttal case, let him have a normal rebuttal case, limited like it should be. This would frustrate the crap out of me. This is something that is so unusual, doesn't normally happen, shouldn't normally happen, and is more difficult for lawyers to deal with and respond to when it's not something that normally happens. And you can tell she's going to give him wide leeway on new information. Jacob, that's how I would deal with it. I would ask for different remedies. I would say this is totally unfair. But let's hear how she deals with it and what she allows them to do.
And what you're asking for initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies, the new...
Remember, by the way, sorry to interrupt again, because she just mentioned the Commonwealth's discovery deadline. It was impossible for them to be able to do their work because of the federal government being under contract and not allowing them to hire them, not allowing the defense to hire. I don't like when people say them and he and she. I like to be specific, right? From not allowing the defense to hire the ARCA witnesses until very late. So it was physically impossible for them to be able to get this stuff done. And now she's holding it against them and giving the Commonwealth additional leeway. It's frustrating.
New information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right. So I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objection?
we can define the scope after we hear from ARCA, which again leaves another item open. I'll tell you what I hate during trial is open items. I hate open items during trial. And that's what she just continues to do. And again, it seems like a maybe that we know is going to land on the Commonwealth side. And it is not unusual. This is not the first judge that would side with the prosecution. I do not think she's in the pocket of the prosecution in this case. And I know that's going to annoy people and whatever. I don't care. People that are like, I want to hear you say somebody is the devil and I want to hear you say somebody should be crucified for this. It's like, I'm going to tell you what I think and how far I think it goes. And that's my personality. That's how I do it. Okay. I think this is a horrible decision. I think it is so annoying and so frustrating. I think it is telling that when the defense does something like this, she says, I have grave concerns. This is horrible. I'm going to publicly shame you. And when the Commonwealth does it, she's like, I'm going to give you more time. I think it's completely understandable why this happened. And the defense, I'm going to allow a robust cross-examination. Absolutely, that's telling. I think she personally likes Lally and Brennan more than the defense attorneys. If she has a personal bias of how she just agrees with or appreciates or whatever, yes, I would say I feel that, especially in the things she says that are not legally relevant. But do I think that she is going to do things unethically on purpose that she knows are wrong and knows are going to get overturned on appeal? No, I do not think that that is necessarily what's happening. Do I think that she cares to try and see it both ways? No. Do I think that she's been a good judge throughout this case? No. Would I want to try a case in front of her? No. Absolutely not. I don't care that she was a public defender. I do not want to try a case in front of her. I do not think that she has given them the proper fair shake. I really don't. I would be incredibly annoyed. I'd be calling appellate counsel. Can you believe what this judge is doing? If I was in her courtroom, I would not be a happy camper. With the Commonwealth's expert getting to rebut the defense's rebuttal, will the defense have an opportunity to rebut the Commonwealth's rebuttal to the defense's first rebuttal? They don't know what we know. They know we know. So it seems like the answer to that is yes, because she said she is going to give them the opportunity to call witnesses again after hearing what this new information is. Now, it wasn't clear to me whether that means the new information they get from the timing during the Commonwealth's case in chief, that they'll be able to recall witnesses in their case in chief. So I don't know. Some of that timing was confusing. If the defense thinks it's necessary, I think they should definitely ask for it. I think this was the end. Let's hear the end here.
These circumstances, a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
All rise for the court, please.
All right, so that was it. Yeah, that was it. This will be huge on appeal, right? I definitely think it's going to be an appellate issue. It's just anytime you do something different, it really creates potentially an appellate issue. I will say she is trying to leave this as open-ended, which has as many potential remedies to fix this. The defense is going to have to make sure they properly document the record in what they ask for. Because if they don't ask for anything, she's like, I offered you more witnesses, just like last time with McCabe, when they said we did all the damage we needed to be done. That was held against them multiple times. You could have done X, Y, and Z, and you didn't. Hi from Massachusetts. Not knowing how long direct and cross and redirect and recross will take, how do witnesses know when they'll be up? Do they wait in the lobby for days? P.S. My sis and I call you the lawyer we love. Awesome. Thank you, Carol. So yes, usually we give witnesses a block of time like morning of Monday or afternoon of Monday or maybe afternoon of Monday or morning of Tuesday, and sometimes they do have to sit there longer. Aaron Wright. Bev promised the defense could cross cops on police procedure, but sustained all the Commonwealth's objections, so they didn't get to. She'll do the same with this. Can the defense request Easter again? They can request Easter again. I feel like they have gotten into a lot of police procedure, but maybe not all of it. I don't remember. When will you admit Karen Reed is not getting a fair trial? Well, I just said I don't think this judge has given her a fair shake here, and there have been multiple calls that I think are completely unfair to her. So I mean, and I said I had a problem with counts 1 and 3 still going forward, and the prosecutor is not giving her a fair trial. But whatever, it's never enough for people. Okay, it's never enough. Lavelle. So if she is found not guilty, then that's it. Yes, that's it. They can't charge anyone else. They could They legally could. I don't think practically they will, because Karen Reed will be the number one reasonable doubt for anybody else that they call. If that's true, then that makes all of this even sadder. I agree, because the only thing that will be proven is the Karen Reed didn't do it. I want to comment live, but I went back to the beginning. Keep up the great fact-based analysis. We're currently taking a beating from the conspiracy crowd. We're not taking sides, just speaking truth from actual experience. GPness, how is it normal that judges tend to side with the prosecutor if law is innocent until proven guilty? You tell me. You tell me. I got a problem with it. I hate it. I try to talk to as many judges as I can to not do that. A lot of them were former prosecutors. So were a lot of defense attorneys. But that's just how it is. And maybe it's just I feel that way because I'm on the defense side, but a lot of lawyers feel that way. True Crime Junkie watched Bettero on Defense Diaries the other day, and he said it best. Brennan is simply unmatched against this defense team, and it's showing. It is 1 against 5 as well, right? The ghost of Brian Higgins' SIM card. But if they call JM back, do they get to ask leading questions? They should, yes, because she would easily be a hostile witness. Hi from Scotland, Peter. I have been following your work for 2 years now. Awesome. Thank you. I want to thank you for consistently providing us with valuable content and for the effort you put into these videos. Thank you so much, Kieran. Skystar's page. Is there anything we can do to help fight for fairness? I understood Proctor wasn't present, but he wasn't alone. Yes, you can write letters to your local representatives. You can vote certain people in and out that can have effect on these changes. You can peacefully protest. Patrick, what motions would be filed now? Potentially Mike Easterly. I think they're doing all the right things. At this point, I can't rack my brain to come up with every motion I would potentially file here. Unpopular opinion. I think this is a massive opportunity to take the prosecution to appear incompetent and doubt their entire timeline. Oh, I don't think it's going to be a unpopular opinion. I think maybe if you're saying it was good for them, but it is absolutely a massive opportunity. I agree with you. Isn't there any form of accountability for judges? Yes. There are committees watching. There are people that are appointing judges, that are voting for people appointing judges in this jurisdiction. That can absolutely make a difference here. Mary Smith, Commonwealth should put on their case and stand by it. Changing their timeline now looks weak, but someone's freedom's at stake here. It's disgusting. And I think the defense will highlight that. I really do. LYK, did you see the Penny McGee case? I did not. But I did hear Bev ruled from the bench in her favor. We were shocked. XOXO from Detroit. I did hear that. Azam, if Karen Reed is found not guilty, can they still have a meeting with the appellate judge to discuss how Judge Cannone was in court? So no, there will not be an appeal on this case. But there are committees that watch and discipline judges and make sure that they're doing the right thing, that they're acting with integrity and ethical behavior. So you could potentially appeal things to them. But again, it's very different if it ends not guilty. Usually they'll say, hey, Judge Cannone did the right thing. How can Karen Reed complain? She was not guilty with the decisions that Judge Cannone made. That's usually how it happens. Will this case influence the civil suits? Yes, it absolutely can. Will it? I don't know. We'll kind of see how that goes. Parkland shooter judge was disciplined and no longer on the bench. Absolutely. There are avenues and remedies. All right, last question here. Brian M. Ask any MMA fighter, reverse side swipe, or beat down under oath. That would have been an interesting expert. I would have liked to see that expert. Piney Woods Law and Crime, thank you so much for gifting 5 memberships on the way out here. You guys are the best. Hope you all have an amazing weekend. I'm going to go enjoy mine. Hit the like button, subscribe. We're so close to 500K. Tell your friends to subscribe. That's all we got. Until next time. Peter, do you believe there'll be a hung jury? What is Massachusetts law on retrials? They can continue to retrial. I think it's very possible there could be another hung jury. I am out of here. Till next time. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.